This is another cleanup item, since this bill itself is a cleanup bill from permitless carry. With regard to pending charges of unlawful carrying, the simplest example is that we put in a provision that allowed for a person to have expunged a conviction of unlawful carrying, which would now be nullified under the new law. The issue that was found with that, which I believe is just an unintended consequence, is that if, for example, person A and person B are both charged with unlawful carrying prior to this, prior to permitless carry passing, if person A pled guilty to that charge 2 days before Governor McMaster signed the bill, they would be able to get that conviction expunged, because that's what we passed, because of the fact that now that is nullified, it is no longer unlawful. However, what we did not consider at the time when passing that legislation is that person B, who has the same charge that was pending prior to the passage of permitless carry, pleads guilty after Governor McMaster signs it. Because we put in here prior to the signing or enactment of it, now person B is prohibited from having that expunged. And so this is just to make it fair across the board. And so what this would do is allow, well, say that the state will dismiss the pending charges of unlawful carrying that would be nullified. Only those that would be considered nullified under the permitless carry.
If there's a dismissal and that's the basis upon which probable cause was for the other charges, if it's dismissed, then it may very well end the case entirely. And I don't think that's what your intention is.
No, that's not my intention. And I remember us having that conversation. And so in this amendment as well, towards the end, it says, notwithstanding the savings clause contained in Section 25 of the Act, and going to Section 25 of the Act, it talks about the repeal or amendment by act of this law. That would address what you're discussing, which would not then be an avenue or a vehicle to dismiss any subsequent charges. But I do understand your concern. It's a legitimate concern, but I don't believe that this amendment would do that, what you're thinking of.
Senator, I'm going to need a little time to look at this. I want to make sure that nothing that we do here today alleviates criminal responsibility, because if that's the probable cause, for instance, if a law officer looks in the car and sees the gun, okay, and then that search led to whatever it was, trafficking children or trafficking cocaine or whatever it was, I'm concerned that that probable cause goes out the window with the dismissal. And I want to make sure that I just haven't had a chance to look at it, and I'm sorry, but that's a very important tool for prosecution in South Carolina.
Right.
But I agree with you in theory. If it wasn't against the law and it was constitutional before, it ought to be constitutional now. So I'm with you there. I just want to make sure that the dismissal doesn't then also take out the basic criminal charges.
Typically, the gun charge is usually the subsequent charge, because it's probable cause for something else like the smell of marijuana. However, I'm happy to add in any language that would say,
well, Senator,
yeah,
would you?
But I'll be happy to temporarily carry it over so we can fix it, yeah, and come back to it. Okay. Move to carry over.
Those in favor of that motion would say aye. Opposed, no. The ayes have it. The amendment is carried over.